Good morning and welcome to the fourth meeting of the Education and Skills Committee in 2020. Can I welcome to committee today Oliver Mundell, who is substituting for Alison Harris, and congratulate Jenny Gilruth on her promotion to become Scottish Government Minister. And obviously Jenny's experience in teaching has been a great asset to the committee over the last few years, and we wish her all the best in her new role and thank her for her contribution. I remind everyone present to turn their mobile phones and other devices to silent during the duration of the meeting. Agenda item 1 is an evidence session on the Disclosure Scotland Bill from the Bill team, and can I welcome Kevin Lee, Disclosure Bill team leader, Disclosure Scotland, and Gemma Grant, lawyer, Legal Directorate of the Scottish Government. As the committee is aware, we arranged this additional session between stage 1 and stage 2 to assist with our consideration of potential amendments. Today we will hear from the Scottish Government Bill team on government intentions for stage 2 amendments, and therefore can I invite Kevin to make some opening statements and on the planned amendments before we move into questions from the committee. Thank you.
Good morning, Convener and committee members, and thank you for inviting us to provide further evidence on the Disclosure Bill. The policy note which the Minister provided to the committee explains how the bill interacts with the Rehabilitation of Offenders Act 1974 and the recently passed Age of Criminal Responsibility and Management of Offenders Acts. In considering the note, it will be helpful for the committee to keep in mind that the changes we are proposing to the 1974 Act are principally concerned with the rules on self-disclosure of unspent convictions under that Act and how those rules relate to the content of a Level 1 disclosure. At present, the rules for self-disclosure and the content of a basic disclosure, which is the equivalent to the Level 1, are broadly aligned. So the disclosure system therefore backs up the duty to self-disclose unspent convictions, as it can be used by organisations to verify that the person has told the truth when disclosing previous convictions. As the committee will be aware, there are separate rules for what is referred to as a higher level disclosure regime to be replaced with Level 2 disclosures in the bill. With Level 2, there are special rules on self-disclosure of spent convictions after they have appeared on a Level 2 disclosure. The changes described in the policy note do not affect these particular rules, since these are contained in secondary legislation. As set out in the policy note, we need to amend the 1974 Act in order to give full effect to the bill provisions on childhood convictions. If we don't do this, then people would have to self-disclose unspent childhood convictions for minor offences that would be unlikely to appear on state disclosure if there was a case-by-case consideration of what ought to be disclosed. To protect individuals from over-disclosure of unspent childhood convictions, the rules for self and state disclosure need to more closely mirror each other. As is the case just now with basic disclosures, a Level 1 disclosure is available to any individual for any purpose. They tend to be used for general employment purposes, but not for jobs with access to high-value assets or for work with vulnerable groups. The biggest users of this level of disclosure at present are agencies who offer to process disclosure checks for businesses recruiting in industry, for example in construction, retail or hospitality. Outside of the proposed mandatory PVG scheme, there is no obligation on organisations to obtain a state disclosure for any particular role. Some employers and organisations within the insurance industry do not obtain state disclosures as a matter of course. This means the duty to self-disclose might be the only safeguarding measure which should ensure that organisations find out about past convictions when a person is applying for a job or for insurance. For this reason, we cannot end the duty to self-disclose unspent childhood convictions entirely, as it could lead to employers and insurers making uninformed risk-based assessments. We therefore need bespoke rules on the self-disclosure of unspent childhood convictions, and we need to ensure that these are generally reflected in the rules on state disclosure, so that individuals are not at risk of over-disclosing their criminal past. Under the approach we have set out in the policy note, the majority of childhood convictions will become spent immediately. This is the same approach taken under the Management of Offenders Act in relation to children's hearings disposals. As a Level 1 disclosure can only include information about unspent convictions, there will be no disclosure of childhood convictions in the vast majority of cases. By making most childhood convictions spent immediately, it will make it very clear to young people what they must self-disclose. This general provision is subject to the clear and understandable exceptions described in the policy note, ensuring public protection is served and that individuals will know their legal duties. And my colleague and I would be pleased to take any questions.
Thank you very much, Mr. Lee. And open question from Dr. Allen.
Thank you very much. Just a relatively self-contained or simple question, I think, but it's about the PVG process or the disclosure process as it might affect voluntary organisations and particularly religious groups. I was lobbied, as it were, by the churches just recently who were pointing out that they're very supportive of the changes, but that I think at one point in the process they're asked to categorise their activities as leisure activities. Now, I think people are probably not quick to take offence, but I mean there might be some people who would hesitate to bracket their faith organisation alongside a golf club, so that there might be an equalities issue there to look at. But I think more substantially the point they were making to me is, would it not be simpler just to have a box that could be ticked for religious or faith groups to avoid confusion in that part of the process, because they already have to deal with quite a bit of confusion when it comes to how people fill these things in. So it was really just to ask if the government had any intentions around responding to that pretty self-contained question mark about one bit of the process from some organisations.
And the intention with the activities that are described in the Schedules 3 and 4 that describe what essentially is regulated roles, the intention was never to describe in forensic detail every single possible role that could exist across Scotland. So what we went for was a kind of broad description of some activities to capture what we mean by regulated roles, and that sits alongside the meaning of contact, because the two parts must come together. But certainly we can look at that feedback from the religious establishments to see whether there's a way of better catering for their interests.
And the government's intention is certainly to publish guidance to sit alongside the lists of core activities in the schedules. So that's perhaps a point that could be addressed in guidance, so that religious groups know which categories within the schedules apply to their activities in particular.
Okay, thank you.
Mr. Johnson?
Yes, I'd just like to...
Sorry, was it on that point, Rona? Sorry, no. On you go, Daniel, sorry.
at all. I wouldn't want to get in run as me. No, I just really wanted to follow up on the issue in terms of codifying the principles underlying the two-part test. And I note from the note that's been provided by the government that it is the intention to bring forward amendments which would put that on the face of the bill and doing so in a way that will be amendable by secondary legislation, which I think is welcome to have that commitment. But I would just ask whether or not there's the possibility of any further clarity, because obviously there's a number of different approaches that could be taken, and indeed ways in which that those principles could be fleshed out. I'm just wondering if there's any further information you could provide at this time.
Well, I can confirm that, as we'd set out in the correspondence that's been sent to the committee, the intention is to bring forward amendments that address what the committee has recommended in terms of some codified principles to be on the face of the bill, which will be amendable by secondary legislation. Those principles will be based upon the case law that we have discussed in previous sessions, so they will reflect those. But the intention would be not to be limited to just those principles, because obviously we've committed to the statutory guidance, which we'll consult on with stakeholders, so that there could be factors that come out from that piece of work in terms of what should be in statutory guidance. There could also be matters which would be relevant to take into account when applying that two-part test. And to confirm that those amendments, the intention is to bring forward those amendments at stage 2.
And just further to that, given that there's a commitment there to make those principles amendable by secondary legislation, I assume that would be amendable by the affirmative procedure rather than negative, because obviously altering these principles could potentially have quite a significant impact on the effect of the legislation. Is that the government's intention?
The intention is to have the codified principles as a set of two lists of principles that decision makers may take into account when when applying both parts of the two-part test. So the relevance and ought to be disclosed, recognising that the principles for each test are slightly different. They're overlapping to an extent, but there are some different factors. They're not intended to be a definitive list of factors, as Kevin said, so they're simply principles which may be taken into account, and any proposals to amend those by way of secondary legislation would really be to reflect any significant developments in case law, to give the government flexibility around that.
Just finally, I mean, obviously one of the key areas where I think there was concern about how the two-part test might impact or be implemented is around ORI, and in particular in terms of situations of incidents which, in terms of the offence, wouldn't be disclosable because they were they took part when the individual was a juvenile, but in terms of the other relevant information that might be disclosable. Is there going to be an attempt to sort of capture or codify that within the principles? Because in terms of the response, essentially, if I can paraphrase, the government's response is that essentially we should trust the probity and robustness of the decision-making, both of the government and of the police, which I mean, I think is reasonable to do, but it would also make sense to try and capture those principles within that codification of the two-part test. So is that the government's intention?
Yeah, the intention is to apply the codification to all relevant decision makers. So that would be Disclosure Scotland on behalf of ministers, Chief Constable, the independent reviewer. Obviously, the independent reviewer has similar functions under the Age of Criminal Responsibility Act. So the intention would be to apply the codified principles to the decisions that the independent reviewer has to make under that Act also. And likewise, the Chief Constable has duties to provide ORI in relation to the PVG Act in terms of what goes on to a scheme member's scheme member account. So the intention is to apply the codified principles across all three pieces of legislation so that there's consistency of approach there.
And that will explicitly deal with the concept which is in the policy memorandum of adolescence being a particularly sensitive period of anyone's life, I assume.
Yes, and obviously is when Sheena Brennan, on behalf of Police Scotland, gave evidence back at the beginning of stage 1, she confirmed in her evidence that they take into account the person's age at the time of, you know, when they're deciding whether or not to provide ORI. Obviously, as a committee will aware, just to be clear that ORI, there's nothing new with ORI. We're not, there's nothing kind of regressive in the bill around it. It's actually progressive in terms of giving individuals a better, easier opportunity to kind of challenge that before it you know, goes out onto a level 2 disclosure to an employer, for example. But yes, to answer your question, yes, the intention is to cater for the kind of issues that have been addressed across the board for all decision making.
Thank you.
Ms McKay.
Thank you, Convener. Morning. You say that on self-disclosure you're going to introduce a clear set of rules into the 1974 Act which explain which types of childhood convictions will be spent immediately and which ones should be subject to the usual disclosure periods. Can I ask what sort of criteria you're using for that, and when will we know what those offences are?
Well, as we've set out in the policy note, then the intention would be that the majority of childhood convictions will be spent immediately, and there's only a small category of accepted sentences which would follow the normal rules in the 1974 Act. So those are what are called sentences greater than 48 months, which the Management Offenders Act refers to as excluded sentences. And then for sexual offences, anything that resulted in imprisonment greater than 12 months. So the kind of category of accepted sentences has been set out in the policy note, and that will be reflected in the amendments that are made to the 1974 Act.
Okay. And just another point, you say that if an employer has not asked disclosure court for a disclosure, the individual will still be obliged to tell the prospective employer about these types of convictions in all cases. What are the consequences if an individual doesn't do that?
The consequences are that there are certain protections under the 1974 Act. So once a conviction becomes spent, if somebody's asked about it and subsequently, say, an employer found out about that conviction, then the person is protected from being prejudiced as a result of not having disclosed it. Those protections don't apply where convictions are unspent. So it would be for an employer potentially to take action against a particular employee if they hadn't complied with their legal duties to self-disclose, and that maybe had consequences for whatever recruitment decisions an employer had made.
Okay, so then that's between the employer and the employee, is what you're saying, really?
Yes.
Okay, thank you.
Ms Smith?
Ask a question which arose during some of the evidence that we took, including amongst the private sort of discussion groups we were having with some of the stakeholders, about a situation which potentially could arise where there is a complaint that has gone in about the person in any group or society who is in charge of the PVG link, but that complaint relates to them. What happens to the procedure within that group? Who's responsible for taking that forward if the complaint is made about the person who's technically responsible for the overseeing the system in that group?
So is this in the context of a consideration for listing? Whether
Yes, it was put to us by a lady who, well, I won't name the group, but who represented quite an important group, who laid out the importance that within any group or society or whatever it might be, that there would be somebody in that association who is responsible for overseeing the PVG management of the members, as in anybody who's working with children, whatever it might be. If a complaint is made about that person who is actually the responsible adult, what happens in that circumstance? Because it wasn't clear before what the situation would entail.
Well, if it's in regards to a consideration for listening, if it is the person that is ultimately at the top of the tree, if you like, then if there were a professional regulatory body involved, then the regulator would be notified. If it is more in the volunteering construct, then it might be that, depending on the content of it, you know, the police might have a role to play in terms of public interest disclosures.
What would happen in an instance, though, if it was a serious complaint that had been made about this person, and therefore that person decided quite rightly to take a back seat while it was investigated? Obviously, there is a responsibility within that association or group to continue ensuring that that vulnerable children are protected. I'm interested in who would take over that role while that inquiry was taking place, because I can see some loopholes in the legislation if that is not carefully thought about.
Is this in relation to that individual possibly acting as lead signatory if the organisation is an accredited body?
Which they are.
Right. In that case, there are so organisations can also nominate a substitute lead signatory or a replacement lead signatory. So it may be that they're able to nominate another person.
Or is that only in a circumstance if something arose? I'm just concerned that there's a loophole, that there could be a time factor here. If a serious allegation was made about somebody, then normally that person steps back for the period of the investigation. If there is not somebody to take over the responsibilities that person has, then there's a gap, and I'm concerned about that. So I'm just asking how that would be looked after.
Certainly in terms of the protection of children or protected adults, obviously the bill proposes that ministers can impose conditions on scheme members who are under consideration for listing. So in that circumstance, that might be an example of where ministers would impose conditions to ensure children and protected adults are safeguarded. If it's in relation to their functions as the ability to countersign level 2 disclosures and process that kind of information, then there are procedures in which ministers can say it has to be another lead signatory has to take over.
Yeah, thank you for that. I understand that. I mean, these things, I mean, hopefully, you know, we have to accept that these situations sometimes do arise. And if a serious complaint is made, it happens right there and then, when it is exposed in one way or another. And, you know, there's a very short time scale for that. And I don't think we can wait for ministers to intervene on a particular case. I think we have to have a process in there whereby somebody within the association who's in charge of signatures or whatever it might be knows that that's what they would have to do in any circumstance like that. I don't think we can leave it just to government ministers. I think we'd have to have a sort of watertight procedure just in case something else happened when that responsible person organising it wasn't there.
I think in terms of the legislation as it's currently framed, that's more of a matter for individual organisations to satisfy themselves that they have their own contingency measures, and so they have the power to nominate substitute lead signatories or to nominate one or more counter signatories who can continue to countersign applications.
Will there?
So there will be
Yes.
guidance on that.
And these arrangements exist right now under the auspices of the registered persons system, which is changing to accredited bodies under the bill. So these arrangements in terms of a code of practice and so forth exist right now. So that kind of the information sharing arrangements that exist for higher level disclosures are not fundamentally changing.
Could I just ask that the government does take some notice of this, because
Yes.
the person who raised this was very exercised about it, and I understood exactly why. And I think we have an obligation to make sure that we're absolutely watertight in any situation where that lead person did have a complaint made against them. Thank you.
Right. If I could just say, I think that this also comes back to some of the evidence we heard from smaller organisations where they don't have a big capacity, that quite often when they were seeking help in circumstances like this, they were just being directed to the guidance, which was very technical. And I think there perhaps needs to be a consideration of a simplification to make it absolutely crystal clear and easy to access, and that the support should be there for sort of smaller organisations that might be in this situation. Thank you. Any further comments or questions for the bill team? Yep, sorry. Yeah, Mr. Gray.
Thanks. I just wanted to ask about the definition of a protected adult, because that was one of the things which the committee raised, and in the response, the bill team say that you do intend to bring forward amendments to deal with some of those issues. I just wondered if you could provide any more detail of how you intend to do that with the amendments.
I think what I can say just now is our intention is to fully address the kind of concerns that were raised by particularly Scottish Women's Aid, had made valid points in terms of what they identified as some gaps in the revised definition. So the intention is to fully address
With those stakeholders in trying to do that.
Yes, I have personally spoken to Women's Aid about that particular issue.
Rona?
Can you give us an indication at this stage when we will see those government amendments?
They will be lodged by noon Tuesday the 25th, so next Tuesday. Yeah.
We should see them then. Thank you.
Yeah.
Okay, I think that's all the questions the members had this morning. Thank you very much for coming along today. It's been very helpful. I'll suspend briefly just to let the witnesses leave the committee room. Two, which is consideration of the responses the committee has received in respect of its STEM in early years education report. The responses from the Scottish Government Education Scotland to the committee's inquiry recommendations are in the committee papers. As previously agreed by the committee, the intention is to hold a committee debate in the chamber on the committee's report, and this has been provisionally scheduled for Wednesday, the 4th of March. In advance of the debate, I've asked the clerks to inform all those who contributed to the inquiry that the debate is taking place and to invite them to send in their perspective on the report recommendation and the responses. Any submissions received will be circulated to members to inform the debate process. I understand that the next annual Scottish Government Progress Report on the delivery of the STEM strategy will not have been published by the time the debate takes place. However, government officials have been asked by the clerks to provide the committee with the latest publications of data sets that inform the progress report, and these will also be circulated to the committee in advance of the debate. So can I ask members if they have any comments on the responses at this stage? If you contain, and are members content to contribute to the Chamber debate as opposed to discussing the responses at this stage? Okay, thank you very much. That concludes public session for this week, and we now move into private session for agenda item 3.